And now to River State, where reactions have poured in as the State House of Assembly says that the Chief Judge, Simeon Amadi, has acknowledged receipt of impeachment notices against Governor Siminalayi Fubara and Deputy Governor Ngozi, and despite a subsisting court order restraining such action. Last week, the Assembly began impeachment proceedings after lawmakers adopted a motion on allegations of gross misconduct against the governor and his deputy. The claims include alleged budgetary violations, unauthorized spending, and failure to present the 2026 appropriation bill. On Friday, lawmakers resolved to request a judicial probe, but a Port Harcourt High Court issued an interim order barring the Chief Judge from receiving or acting on impeachment materials. The Assembly insists its action follow constitutional provisions and urges calm across the state. Right now, being joined by lawyer and public affairs analyst Justin Obiechina, as he joins us in the studio for more on this story. Thank you so much, Mr. Obiechina, for joining us.
Thank you for having me.
Okay, let me ask you real quick. If the High Court restrained the Chief Judge from receiving impeachment notices, can an acknowledgement of receipt still be legally valid?
Once more, thank you for having me. Formally, yes, to your question, but legally, no, because there is a pending or subsisting High Court order. And yes, he might have received it in his capacity as the Chief Judge, and his actions cannot, or we can't say has a legally binding effect, so to speak, because everybody has to protect the sanctity of law. So formally, he has acknowledged it. It might just be for the purpose of the fact that he was served with the acknowledgement copy and then he had to acknowledge same, but legally no binding effect because there is a subsisting court order.
So does simply acknowledging documents amount to, acting on an impeachment process in, violation of the court?
Potentially, we can assume that looking at the provisions of Section 188, that these steps are being taken or can be inferred to have been taken, considering that an acknowledgement has been made. But like I mentioned earlier, there is supposed to be sanctity of law on all quarters, and the rule of law must be preserved and protected, starting from the Chief Judge of the state.
Now, I'd like to know which takes precedence here, right? The House's impeachment powers under Section 188 or a subsisting High Court injunction?
Okay, so simply, Sita, that which take precedence as it stands now, looking at the fact that there is a valid court order, is the court order. The reason is that the House's power to either impeach or not to impeach under Section 188 cannot or is validly clearly stated, but there is the role of the courts in interpreting every step that is being taken by every arm of government. And when that is done, it is assumed, looking at the step that has been taken by the governor and the deputy, that due compliance has not been followed. Who is best to interpret whether due compliance has been followed or not? It is the court. They are saddled with the responsibility. That's the judiciary's duty. And particularly, any arm of government cannot be a judge in its own cause. If you are sure that you've complied, it is just an interim order. Go and let us determine your fate in the court of law. And obviously, as we know, the court is an unbiased umpire, and the House of Assembly cannot make a pronouncement, which they validly did, premised on their powers as provided in the Constitution, and at the same time turn around and disobey a court order because it was validly issued. Even the Supreme Court has held in plethora of cases that even when a court order is not valid, it still must be obeyed.
So is it possible that the Chief Judge or the lawmakers be exposed to contempt of court if the process continues in any form?
Very well, yes. They are exposing themselves. The Chief Judge is exposing themselves. The House of Assembly as well is exposing themselves. And anybody who falls under this purview would face the law strictly.
Quite interesting. So at this point, is the impeachment process, legally paused, suspended, or completely voided with the court's rules right now?
I like the word you used, paused. That is it. The court only came in to determine if the impeachment process is being followed according to the provisions of the law. Obviously, when anybody is aggrieved, the right channel to go to is the court of law. And who sets everybody in proper perspective? Still the court, which is what the governor as well as the deputy governor has done, as every common man would do, run to the courts as the last hope of any common man. They have done that. Let that be determined by the court. It doesn't stop the impeachment process at the end of the day, just paused. And that should help the House of Assembly to respect that their wishes as representatives of the people is not going to be put, is just going to be put on hold, not completely put away.
So, as it is right now, what legal options are now open to Governor Fubara and his deputy to enforce the court order?
They can bring an action for contempt against the Chief Judge of the state, as well as the officers of the House of Assembly. They can also apply to the court for what we call accelerated hearing, so that at the end of the day, whatever decision that is reached by the court would not be a nullity. Because sometimes when people take the law into their own hands, and at the end of the day, you cannot manage the situation. Maybe a pronouncement is being made at the end of the proceedings, it becomes unable to enforce him, premised on the fact that the actions are already being taken, or actions have been taken, and then to reverse back the hand of time might be difficult. And then lastly, they can also apply to a higher court that the court which they've approached, which gave an interim order, has not been complied with. And I just believe that the actions of the Chief Judge, if truly they want to start following what is provided for under Section 188, and the actions of the House of Assembly members is in contravention as we speak of a valid court order, and they are exposing themselves to liability.
So if the contempt of court is brought to a chief judge, doesn't that make the situation quite interesting? Because here the case now is, so who's going to hear it, basically?
Like I mentioned earlier, the sanctity of law has to be protected. Nobody is above the law. And that's why we have the concept which we refer to as rule of law, including the Chief Judge of a state. Now, the Chief Judge of a state was obviously appointed by some persons and premised on a recommendation that was made. So that's why I also mentioned that they could go higher to appeal to a higher court, and then for that to be determined. As it stands now, the deputy governor as well as the governor of the state can be referred to as just ordinary men who are seeking sanctity in the courts. And the court should be allowed to determine this issue judiciously so that justice can be seen to be done to all and sundry.
All right, so if the Assembly insists it has complied with the Constitution, who ultimately, determines that? Is it the Parliament itself, or is it the court?
Earlier, I mentioned that nobody can be a judge in their own case. The Latin maxim, nemo dat quod non habet, that is, you can't give what you don't have. And then, nemo judes in causa sua. That means to say you can't be a judge in your own case. If the House of Assembly are sure that they are complying with the due process, then who would determine that? It is still the court. And that has been expressly stated. It is the duty of the courts premised under the provisions of Section 6 to interpret the Constitution. What is the House of Assembly following? It is the Constitution. And who is best to interpret the Constitution? It is the court. The court has now said, hold on, let me determine the steps you've taken to see if you've complied. So let the House also respect the court, because I also believe that if they are aggrieved in any way, they would also approach the court. So if they do not respect or maintain the sanctity of the courts now, will they validly run to that same court if they desecrate that same court as we speak now? Remember, he who comes to equity must come with clean hands. So they should keep their hands clean now if eventually they want to, or they at any point in time approach the court to remedy whatever it is that they feel aggrieved by.
All right, thank you so much, Justin Obiechina, for having this conversation with us.
Thank you.